not manslaughter anymore. Is that the difference?
That's correct. It's a higher degree of taking a life. Okay, so that's the charge that you're being charged with now. And you were indicted by grand jury.
Okay, you're aware he was hanging out by Brian and Colin Albert. I mean, we're all in on the same joke, right?
Welcome to Fair and Square Files. Thank you so much for listening in today. Today we're diving headfirst into the Karen Read murder trial. And let me tell you, the anticipation is palpable. As we sift through the latest updates on jury selection, potential witnesses and crucial evidence, it's clear that this trial is shaping up to be a real courtroom drama. With so much at stake and so many unanswered questions, it's hard not to feel the tension mounting. So buckle up, folks, because this trial is bound to be a wild ride. And we'll try to keep you updated along the journey as best as we can, as fair as we can. We're not here to take sides, we're just here to present the facts and maybe go down a few little rabbit holes if they present themselves. Of course, there are so many little details that would be impossible to cover absolutely every single one unless you did a video for about 24 hours. Now let's get straight into it, shall we? Here we go. The Karen Read murder trial progresses with the seating of a jury after meticulous selection from a pool of hundreds of candidates over nearly 5 full days. The trial, set to take place inside Dedham's Norfolk Superior Court, is anticipated to span 6 to 8 weeks once underway. To be honest, I have my doubts about that. I feel like, given the moving parts of this particular case, there is a high likelihood that it could drag on much longer than that, but we'll see. Prosecutors have compiled a list of 87 potential witnesses for the trial, while Read's defence team has prepared a list of 77 potential witnesses. That actually also includes Norfolk District Attorney Michael Morrissey. So, yeah, many names involved in the witnesses from both sides. This is going to be really intriguing. Attorneys are also awaiting rulings on evidence that may be presented during the trial. Notably, the prosecution seeks to admit DNA results obtained from a piece of hair discovered on the tail light of Read's SUV. Check out the following clip from the pre-trial regarding the evidence.
Don't know if it's speculative or if it's relevant. I don't know if it will prejudice or confuse the jury. And if it's hearsay, I have a whole other series of factors I have to consider. So, Ms. Giannetti, are you pursuing a third-party culprit defense?
We are, Your Honor, and I'm prepared to address that. The Commonwealth has raised the issue, and I am prepared to address that today.
So you filed your motions first, and you did not raise it. So if the Commonwealth had not raised it, you did not move to introduce it. Correct? I have no motion from.
No, I
from
understand. I understand, Your Honor. If you'd like something in writing for us, we can do that. I have a full argument prepared.
All right. So who is the third-party culprit?
We are under no obligation to name any specific third-party culprit.
How am I supposed? So you're prepared to argue all this?
I'm prepared to argue it, Judge.
All right. So we will get to that when we get to the Commonwealth's motion.
That's fine.
The defence team trying to keep a few cards up their sleeve for the trial there, I would imagine.
The motion regarding the DNA, regarding excluding the DNA. Mr. Lally, why should I not allow that motion?
For a couple of reasons, Your Honor. Number one, what I can provide to the court by way of update is that most of the testing with regard to that item is complete. So first and foremost, the item is hair. That was confirmed by the body testing prior to them conducting any sort of mitochondrial testing. The mitochondrial profile, the partial profile that was generated in regard to the hair sample is complete. The mitochondrial DNA profile in regard to Mr. O'Keefe's sample is complete. The preliminary analysis that I received by way of email from Bodie yesterday indicated that they were consistent with each other. I asked for some sort of preliminary report or something that I could share with counsel based on their lab's accreditation. That did not permit them to release anything by way of a report prior to it going through a full review process. My understanding is that not only that process, but the entire lab file should be produced by Tuesday.
The following is another clip from the prosecution at the pretrial. This one I found extremely interesting, and I detected a slight embellishment of the truth.
The troopers who conducted that arrest were wearing a body-worn camera pursuant to their BWC policy with the state police. Counsel has a copy of the policy, counsel has a copy of the video, and essentially there are a number of different statements which provide sort of third, fourth, fifth, sixth, I'm not sure what number we're up to at this point, of sort of varying accounts that the defendant has provided to numerous people.
Can you give me an idea now? Do you know the substance?
So the substance of these particular statements is the defendant, Ms. Reed, continuously is told by Sergeant Buchanan to essentially stop talking. He's advised her of her Miranda and advised her to stop making statements, and repeatedly states that to her during the course of her making statements. But the sum and substance of it is she says something to the effect of, are you in on the joke? And then makes some sort of reference to having witnessed Brian Albert and Colin Albert essentially smashed John O'Keefe's head into the taillight, indicating that that's how her taillight was broken. Doesn't make any sort of further statements about why she would then leave the scene after that occurred or anything like that. But these are, again, different accounts that have been made in direct variance to prior statements that she made January 29th to the troopers, to paramedics, to treating medical professionals, to Ms. Roberts, to Ms. McCabe, to the niece of Mr. O'Keefe, to a whole other sort of slew and variety of people with a different sort of variation on what transpired.
I'm going to play you the video potentially in question now. I say potentially because I am sure this is what the prosecution are referring to. This is the video on file. Take a listen and see what you think. For the life of me, I couldn't hear the prosecution's claim there. I could certainly hear Karen Reid mention the tail light, but the sound quality isn't great. However, I could not hear her claim of how that light was broken.
Was a probable cause out of the district court, okay? So the charges that you were arrested on initially were out of district court, out of Stoughton District. That's where the arraignment was. It was district level charges. Today, grand jury indicted you on these charges, which is second-degree murder, vehicular homicide, and leaving the scene of the death. Okay? So those are the charges that grand jury indicted you on. So now you're being charged and will be arraigned in Superior Court, Norfolk County Superior Court in Devon. Okay?
So bail doesn't apply anymore?
Typically, I'm not, so we don't set a bail. But typically, once murder comes into play, people don't get bailed out.
So it's not manslaughter anymore, is that the difference?
That's correct. It's a higher degree of taking a life. Okay? So that's the charges that you're being charged with now. And you were indicted by grand jury.
Okay, you're aware he was beaten up by Brian and Colin Albert. I mean, we're all in on the same joke, right? My taillight was cracked and John was pulverized.
Okay, you need to abide by the rights that were afforded to you, okay? So you can talk if you want. If you wanted to tell us what happened, that's fine. We'll listen, but you were ready to use your rights, okay? And I'm sure he's going to do it again. All right, if you want to talk to us, you want to give us a story, definitely. We'll take it.
No, I mean, I know you already know the story, so I don't need to.
Interesting, isn't it? It is completely possible that they were referring to some audio that we weren't privy to, or potentially witness accounts rather than the actual video itself, but it sounded from what the prosecution was saying that they were referring to the video. Interesting. Well, let's crack on with the case. In recent developments, the defense motion for relocation of the jury box within the courtroom, citing concerns about jurors' ability to observe facial expressions. So that's the witness facial expressions, I'm assuming.
The only people who really can fit in that courtroom will be the press, the victim's family, and the defendant's family.
Well, initially objections were raised. It was agreed that the trial would likely commence in a smaller courtroom to accommodate better visibility for the jury. Attorneys on either side of the Karen Read trial will be given 45 minutes to deliver opening statements on Monday morning. The preceding judge ruled on Thursday, so Monday being obviously the 29th, and then this trial kicks off. Goodness me. Thanks for watching, everybody. And if you haven't already, please remember to like and subscribe. It really means a lot to us. Until next time, be careful out there.